I'd like to call this meeting of the Town of Boothbay Board of Selectmen to order. First thing on the agenda this evening is the Pledge of Allegiance. I'd ask everybody to stand.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Next thing that we have on the agenda is the approval of minutes of the previous meeting, and I'd ask that we hold off till Dale gets here because Steve and myself weren't here for that meeting. So the next thing that we have on the agenda is David Stimpson. Mr. Stimpson.
Mr. Stimpson's requested to be on the agenda.
I think most everyone here is aware that my two sons and I are on our 6th week of being unable to work right now because of the notice of violation, the cease and desist order that we were given. And it's unknown at this point to us how much longer it's going to be before we can get back to work. And this is causing a great deal of financial hardship for us right now. And we believe that the whole issue could have been resolved without having to have been issued a notice of violation. And I guess I'd just like to make a plea that we figure out a way that we could be allowed to get back to work while the town figures out how to redefine the ordinance or how to come up with a solution to the problem.
I don't think once it's a notice of violation, there's nothing we can do about it anyways, is there? I mean, that really is not in our hands, unfortunately. And correct me if I'm wrong, you know the ordinances a lot better than I do, but...
It's my understanding, Mr. Stimpson, that you have an appeal before the appeals board currently.
That's correct.
I think under the circumstances, that's the only way that anybody can proceed, be it the town or yourself. Until that appeal is heard, really there's nothing the board can do for you.
Right, I think you're putting the cart before the horse at this point in time.
I guess the point I'd like to make is that we have done everything that the town has asked right from the very beginning. We have complied with all the requests and haven't done anything illegal. And this is the first. The appeal will be the first chance for us to have any form of due process. And meanwhile, we will have lost at least 4 weeks worth of work, and for probably more like 8 weeks of work. We've already lost 6, so it would be 8 weeks worth of work. And I don't know how many people. I mean, some people, if they're laid off, they can collect unemployment, and that's not an option for us. We basically have no income. So it just seems like there must be some way that at least we can be allowed to go back to work without the threat of fines and everything.
Well, I understand your position, and I understand the situation that you're in. Unfortunately, the notice of violation came from the code office, and they felt that they were interpreting the town's ordinance, the rules and regulations, the way that the town wanted. From my understanding, there was a consent agreement that was offered. You decided you didn't want to sign it, and you retained an attorney. Honestly, Mr. Stinson, I'm not sure your attorney would be very happy if you're sitting here without him talking to us about this.
The town's attorney has consulted with us and said it to avoid the conversation pertaining to the appeal and the notice of violation. So the Board of Selectmen has probably gone further than that. I would like them to go already, but it's their meeting.
I would just like to point out that the consent agreement had me agree to stop building boats. So I don't, you know, I don't see why I should have been required to sign that.
It was not a dialogue
And
given to us.
the consent agreement, well, and then, you know, since I would have to stop building boats, and yet I was, you know, issued a permit knowing what the building was for, I would have to stop building boats. I could end up having to move my business and have an unfinished building that I couldn't afford to finish. And that's why I had to get an attorney at that point. And my attorney met with the town's attorney. The town's attorney, and, well, my attorney pointed out what he thought were some difficulties in the way the ordinance was being interpreted, and then wrote a letter to her asking for a venue for resolving the issue. And the very next thing we got was the notice of violation.
6 weeks later.
Just 2 weeks ago, you know, Mr. Chiasis said that a notice of violation is reserved for last, you know, it's a last resort for when all other avenues have failed. And this is clearly not the case here. You know, we have been proactive for the whole process. We've been in communication with the town. We've asked for a venue for a solution, and we were slapped with a notice of violation. So,
When was the first conversation between you and the town on the possibility that you may have been in violation?
well, I was here at an informal planning board meeting sometime in March, and at that time, the planning board did not seem to think I was in any violation of anything, and they even recommended that we work it out personally with the neighbor.
If you met with the planning board informally in March, somebody must have told you before that, in order to set up the meeting, that you may possibly be in violation. When did that first conversation
Well,
happen?
It was in February that I was made aware that there was a neighbor who was complaining. But at that time, I think that the former code officer did not believe that we were in violation. And I think we can show pretty clearly that we weren't in violation. But what I'm saying is that we've never had any venue for being able to prove that we weren't in violation.
But you actually do. It's the Board of Appeals.
Right, but
And unfortunately, this board does not have the authority to throw out a notice of violation that the code office gave you. The only ones that you can appeal the notice of violation to is the appeals board.
For clarity, when I came to the realization that there was something going on River Road, I didn't know it was Mr. Stimson's property at the time. We sent the code enforcement office out there in February, so last winter. But we've since printed up all of the dialogue that's happened since the beginning of this case to now, pursuant to a freedom of access request, and there's been discoveries on that since September of last year. So this has been going on for over a year in the eyes of the town. So the town's been working on this for a year.
Unfortunately, there's really nothing we can do. I mean,
Not the way it comes.
exactly. It's got to go through the appeals
Then
process.
it has to come to us.
You know, if the Board of Appeals upholds the code enforcement's notice of violations, the next step is the Board of Selectmen for to take it through the legal process.
Yes, sir.
Would the
Could I ask you to identify yourself?
My name is Alex Rio. I own Esoteric Woodworks. And personally, this same situation happened to me over my own naivety in where I lived and what I was allowed to do. My situation worked out a lot better than David's situation. Is the consent agreement still on the table? And could there be the last line in the writer, you will not build any more boats dependent on the boat, on the town ordinance, or however we resolve this next May, so that he could at least get done what he's got done, make a living, and prepare himself for whatever case he'd like to present about the ordinance or clarifying the ordinance.
If there was if the notice of violation has been issued, if there was a consent agreement, and Mr. Stimson still continued with his appeal to the appeals board, and the appeals board felt that there was no violation, if the appeals board feels there's no violation, then there is no violation, and the consent agreement would be null and void, and Mr. Stimson would be able to do as he's doing. But the appeals board hasn't heard the case yet. They haven't seen the evidence from either side. That's just pure speculation.
Well, my question was, is it just still on the table so he could sign it and be at work tomorrow?
That's something you'd have to go through code.
The consent agreement hasn't been through the board of selectmen.
Right. That's, we haven't, I've just heard about a consent agreement. What's in it? I mean, Jim would know, but we don't.
The consent agreement is the code enforcement officer allowing a violation to go unpunished until the terms of the agreement are met. In the consent agreement that we negotiated, it did say that boat building would cease to happen at a specific date unless the law is overturned. I can't remember the exact wording of that, but that's how it was worded.
Is that still available from the code enforcement officer?
We've taken the consent agreement off the table for now because we've had a freedom of access request that really complicated the local government structure. And it took a long time to comply with that freedom of access request. And we think there's a lot of scrutiny on the process. So right now it's more important to the town that the Board of Appeals process retains its integrity than the consent agreement.
Does that answer your question, Alex?
Yeah.
I'm George Goodwin. I'm a retired boat builder. I work for David, and everybody works for everybody else in this town. And we work all the different yards. We'll go around. Is this the best you guys can do?
We shouldn't be talking the way we are right now.
No,
This
but
is
is-
more than we should do.
I understand that, but I'm asking a question. Is this the best we can do? Is this the best you can do?
I'm not sure I understand the question. Is the
This is-
consent agreement the best that we can do?
The letter to the editors, this guy said, fix it. If these guys are out of work, we're out of work. They're making no money. It is the dumbest thing I've ever heard. Is this the best Boothbay can do? Really? I'm really just chewing your ass out right now. It's horrible what I see happen. They're passing the buck, you pass the buck, this thing is down the road. You kick the can down the road. This guy's out of work.
I don't look at it as passing the buck.
Well, you're kicking the can down the road, Buster.
There's a process that needs to be followed, and unfortunately, the ordinance of the town of Boothbay is voted in by the people.
Yeah.
If the people want to change that ordinance, they can.
We're the people.
We are the people.
Right.
Unfortunately, it doesn't come to us to change. It would need to go through town meeting for a town meeting vote.
And there's still
a process as
Right.
well that needs to be followed in order to make those changes.
David would be completely bankrupt by then, so it's pointless.
Excuse me,
Yes, sir.
Mr. Cunningham, it seems to me that the circumstances, Paul Baines is his
And
name,
who-
the necessary circumstance of putting David out of work while resolving an internal conflict within the town, because you had a code enforcement officer that was an employee of the town who decided that what David was doing was within the bounds of the ordinance and legal. You had a new code enforcement officer in town who decided in adversity of that. So there's obviously a conflict of resolution within the authority of town and reading and implementing your own ordinance. At that point, it would seem prudent to me that maybe a process of trying to sort this out, which may include David, is important, but it's not necessary in a notice of violation in this circumstance to issue a cease and desist. It may be necessary to issue an order of violation, to carry it to appeals, to see that your ordinance is properly implemented. The cease and desist on work on David can be released by town until the appeals process is done, and there's state precedent to say so. The state precedent also states through the Maine Supreme Court in a suit brought to Casco that deference is paid to the previous authority. So the code enforcement officer that issued David in full knowledge of his work, the permit to do the process is to be considered by you and by the town manager to have deference in the circumstance. David should not have been asked to stop work. when the appeals process is finished, and the Board of Appeals gets to decide whether to issue a stop work order or allow it to go to Superior Court. He should be allowed due process, and that would be due process, and that would be prudent action on your part. To put this man and his 2 sons out of work because you guys can't decide what to do does not seem prudent. And the one prudent action you can take through this process, and it's your legal responsibility and right to do so, is to give him permission to go back to work and continue the process of appeals. Thank you.
Here.
Apparently, David has not explained this correctly to all of you folks, and we can't do that. We're not allowed to.
No, there's a couple of things that there's some factual misunderstandings in your statement. The permit that was issued by the previous code enforcement officer is still valid. We have no problem with David building a New England style barn like he has applied for. No other applications have come before the town other than the application for that barn. When a building permit like that is issued, the use for it isn't something that we usually ask for. But a stop of work or the stop work order is standard and routine for practices that go through a notice of violation.
Is there a conflict within the ordinance of the town of Boothbay in regards to manufacturing and boat building? Is it not state in the town ordinance that boat building is to be considered a maritime heritage activity and is to be allowed in every single zone in town, but manufacturing is only to be allowed in certain areas? Is that not true? These are the circumstances with which your officials in this town, your code enforcement officers, are in conflict. It's on how they interpret it. The previous code enforcement officer knew in full knowledge what David was doing on his property. Because it didn't say so in the documentation, and having dealt often with code enforcement, the code enforcement officer gets to say, no, you're not a problem with what you do, you just need a permit for the building. That's the crux of the conflicts here. David did not just start boat building on his own without anybody knowing what was going on. So let's not pretend that somehow this is some mystery that just sort of showed up and he got a permit just for the barn. Let's be honest here. The fact of the matter is you do have the authority to allow David to continue to work until due process says that he is indeed in violation. Because he followed all of the rules, did exactly what was required of him by your ordinance and by state law, in the process of proceeding to do this building and continue his business, you owe him that, and you should give him that right to do so. You can still go to the appeal, you can still follow all of the rules that are necessary for you to resolve this legally in the process that you are claiming it's necessary for you to do without him being out of work. The state law says that that can be done, but the person who is filing for the appeal, which is David, takes the risk at the time of the appeal being turned down of bearing that burden. If he's willing to do that on his own, you have no reason to hold him back. You have no legal reason and you have no prudent personal reason to hold him back. I don't understand why, in today's market, you guys would do this.
Could this not have also been worked out with a consent agreement between Mr. Stimpson and the town if, as Mr. Chayocha says, there was a clause in there stating that if the law changed due to the Board of Appeals vote, it wouldn't have to be looked at, which would have also allowed Mr. Stimpson to continue his work uninterrupted on both of the boats on which Mr. Stimpson, as he himself admitted that he's working on. Wouldn't that consent agreement have served the same purpose, what you're saying right now?
If the consent agreement that you speak of, yes, I would say that, under this circumstance. If the consent agreement that you speak of had put it in those words, yes. But the consent agreement that you speak of defined very definitely the beginning and end of Mr. Stimpson's boat work, and it wasn't the ordinance. It defined that he was allowed to do a certain amount of work, and when that work is finished, he was over. If he signs that consent agreement, regardless of what your ordinance does, he's done. Now, if he says you can continue to work, to do this work, and if things change in the future, continue to carry on your work, that's a whole different program.
Based
The
on
process-
the wording, based on the wording that Mr. Chaosis just said to all of us, I disagree with you, sir.
And let it be
But
known,
based on that same wording that I read, that's not the case. And one has to be careful when they're being advised by counsel to offer their signature to a restriction.
all of the dates in the consent agreement were proposed by Mr. Stimson.
I understand that.
So it's not like we made arbitrary dates. We asked Mr. Stimson what he would be, what would he be amenable with.
All right, then let's take that particular circumstance. You backed a man into a corner who's trying to make a living with an agreement that says either you do what we say or you're out of work. That didn't include the due process of trying to find out what's in the best interest of Boothbay and how to amend your ordinance. The fact of the matter is still, if it was okay for him to continue to do that work under a consent agreement, why isn't it okay for him to continue to do that work until the appeals process is finished?
What protects the town and
The appeals process protects the town. You are at no risk here. There just makes no sense to me. There is nothing logical that I understand about any of this process. And I've been a chairman of the planning board for Bonham. I've been on a planning board for 6 years there. I go through this stuff all the time. This makes no sense to put him out of work. I understand having to go through process to resolve yourself with your own ordinance, because these ordinances have conflicts, and we need to figure them out and sort them out. But to have him bear this burden is irresponsible.
Douglas didn't catch your name, and neither did I, sir.
Paul Baines.
Paul Baines, thank you, Mr. Baines. Martin, you had your hand up.
I was just asking if there was a permit issued, and I think you told me there was a building permit for the barn.
or New England style barn, yes there
Okay,
was.
for the barn. But at the same time, he didn't ask for the boat building to be in the barn? Is that
No,
what,
and-
that's what you, in question? part of it?
It's the town's opinion that Mr. Stimson can build that barn right now.
Okay, but he's not allowed to use it to build.
We talked
boats?
about the use many times, Jeff and I did before that.
And just to clear up, there was some discussion about the previous code enforcement was okay with the use. I specifically asked the previous code enforcement officer whether he was gonna take action on this prior to him leaving, he did not. He chose to lead it into the next code enforcement officer, and we put it in their hands.
Why did he choose not to?
You would have to ask him. I mean,
Though you're his boss, why did you choose not? You were in a situation of authority over your own code enforcement officer who you directed to take care of a circumstance and he chose not to and you don't know why?
there was a lot of things that didn't get done in the last few months. This was one of them. Priorities being said, he wasn't able to attend to the notice of violation for Stimson Marine.
Yeah, well, this process is where it stands right now because of the decision that David has made, and it's as simple as that, and we can't stop that.
That's ridiculous.
No.
Bruce?
Yeah, thank you, Mr. Chair. I happen to have seen that consent agreement, but I'm not a lawyer, and it was some time ago. But my recollection was that it would have allowed David to continue either the holidays working on now or one more. I can't remember whether it was one or two.
June
And then
1st.
cease and desist in that use of the property and turn the barn into another use. I think it was instrument making that was talked about in that consent agreement. I think that by signing that consent agreement, he would have been agreeing to the end of boat building on that property. And so I think it's a red herring or whatever the right word is to say that he could have avoided all of this by signing that consent agreement, because he would have been signing away his right to do what it is that he wants to do. I know he loves instrument making too, but boat building is what's bringing in the bread. That's the work that he and his family are doing, and that's what he was doing, and he would have been put out of work essentially by next June or July, whenever the dates were in that consent agreement, by signing it. So I don't blame him for not signing it. I wouldn't have signed it. So I don't think that's a resolution to this conflict. I think the question really is, I guess I have a question. Did you, as a board, take any action in this whole matter that you could reverse, that would make things better?
No. Bruce, this has
I
never
don't-
come
that
before
was-
the board.
That was a rhetorical question. So I know that you didn't take any action. It was really the zoning board that put the law into place.
No, the planning board hasn't worked.
Well,
on
the
it.
town meeting put the law into place that's
Right.
now caused through the zoning board, through the board of selectmen, to the town meeting that is causing this problem. So I understand that you didn't do anything, but if you do have the power to remove the cease and desist, as this gentleman says, and I don't know that that's true or not, but that seems eminently reasonable to me to let him go to work while this is under appeal. It just seems like grossly unfair to me that you put three people, the town, through its processes, has put 3 people out of work in a traditional industry that has been done around town, that I don't think anybody had the intention of preventing when this ordinance went into effect. So if you have that, if you can do that, as this gentleman seems to suggest, I think you have very close to an obligation to do it, for the history of the town.
I don't disagree
and
with-
for the And for the good of the employees and the family that are building.
I don't disagree with you, but unfortunately, this gentleman doesn't represent the town of Boothbay. Without knowing whether we can, I would never dare to do that.
I'm sorry, I don't, is it okay if I ask a couple follow-up questions, or make a couple?
Go ahead first.
Thank you, Chuck. Then I would ask that the Board of Selectmen undertake immediately to find out whether they can do that or not, and then meet in a special session and do it. I mean, it causing, incredible harm to this family, and setting an awful precedent in terms of the historical work that's been done around this community for centuries. So,
I think, Bruce, just to follow up on that, I think we'd also be setting a very bad precedent if we get involved in notices of violations that come from the code enforcement office.
Yes, and
Excuse me, I'm losing my voice again.
Yep.
And not let them follow the process of going before the appeals board.
right, and I agree with you, Mr. Chair. You should not get yourself involved in that process, but if, as a separate matter, if you can deal with the cease and desist while the appeal is going on, and I don't know whether you can or can't, but if you can, I would ask you to look into it and then do that. The second question I have is, why does the appeals process take so long? Do you have no influence, or who has influence on the appeals process?
It all depends on when the notice of appeal comes in, and they have, 30 days to hear it,
Right.
per statute.
The appeal was applied for on the very last day of the appeal process. So it wasn't like the town was waiting. The town wasn't holding up the process. As soon as the appeal was received, a date was set. Notification is being sent out right now, so that the date, and I can say it right now because notification is being set, but November 1st will be the date of the appeal. That was the first date that all of the appeals board members and council was available.
So he's out of work for another month.
I mean, the appeals opportunity is a certain length too. It wasn't like the appeal was applied for
I
within the
understand
first
the
day.
time limit that they've got with which they get to file, and that they wanted to make sure that their paperwork was in order, and I understand that part, but I am still extremely, I don't mind that you guys want to do an appeal, I don't mind that you need to sort out your ordinance, all that stuff seems like it's proper to do, and that the process that you're using and implementing is the process that's there for that. The part that's not necessary was to put them out of work. The state law clearly states that should the code enforcement officer find it a prudent application to allow the applicant or the town person in this particular circumstance to continue to do that process while they appeal, if the town person, in this case Mr. Stimson, is willing to bear the burden of the cost of doing that should the appeal go against him, it's within his right, and you should give him that opportunity, because this really is, you can say what you want, but there really is clearly some confusion between your last code enforcement and your current code enforcement about how these particular aspects are being interpreted. And you guys also know that if there are parts in your ordinance that state that boat building specifically as a heritage is something that we really want to value in Boothbay and continue to support anywhere it's done, and so many of our boats are built in people's backyards, that you really do have something internally that you need to look at that may just be a simple oversight in your ordinance, that something got stuck in one place and the other. It happens to ours all the time, and this is what we do. We try to sort these things out. It's not necessary to keep these men out of work any longer. It's just, in today's economy, it's hard to justify that approach. It just seems prudent to say, fine, David, go ahead and go back to work. We got the legal process is going to get carried through. The paperwork is set up. Nobody's at risk here. There's no reason to let this stand where it stands right now. Go ahead and go to work, and if the appeals process says you're in violation, then the legal procedure that's his right will dictate the final outcome of this for all of you.
I disagree that that nobody's harmed in this, because if Mr. Stimson does go back to work and the town is not enforcing the ordinance as written, what about the rights of the property owners?
The town is enforcing its rights through the process of appeal. That's the legal avenue the town has chosen to use, and it's your right to use and David's right to use. That's what it's for.
The consent.
That mechanism is for due process, not someone else's decision that something is awry. And that's the purpose of it, is to make sure that a body of individuals from town have the opportunity to look at both sides of this program and decide where the line gets drawn between right and wrong.
A consent agreement would be more clearly defining that the town is enforcing the laws as written until the laws can be amended. In the meantime, it's just simply the appeals process on the notice of violation. Where's the teeth in that?
Well, the problem, and I'm going to go back along with our friend here on the end, the consent agreement that I read stated specifically where Mr. Stimson's boat building ended. It didn't state that if the appeals process and/or if the town did not vote to change the ordinance and/or it said you get this vote and you're done. And if he signs something like that, regardless of what the town ordinance change does in his behalf, you have a legal document that says he's done. And I don't blame him for not signing that. If you had simply said that until this process is completed, this is where we're going to go, that's a very different wording. You backed him into a corner he couldn't say yes to, and I don't blame him.
Mr. Stimson didn't provide any alternate language to that consent agreement. We were very amenable to constructing the consent agreement so that it would appeal to Mr. Stimson and the town of Boothbay. We wrote the consent agreement on the hood of my truck at his place of business. All the dates were arrived at. All the dates were arrived at by.
All I said,
Mr.
it doesn't put him back to work. And my point is simply this. All right, the process is already going. This thing is going to go to appeals, and there's no doubt about it.
Right.
It's not necessary to keep him out of work. If the appeals process goes through, and the town appeals board says, Mr. Simpson, you are clearly in violation of the ordinance, and this must cease and desist, then David has no choice at that point but to cease and desist. And why, until that process, is it such a difficult thing? When no one is at risk and no one is to be harmed by him continuing to work until due process is completed, this is something that I don't understand.
I would ask Mr. Stimson's lawyer, because my direction to our lawyer was that we need to have the consent agreement finalized by a certain date, or we are going to issue notice of violation. When that date came about, we asked our lawyer, where is the consent agreement at? And that is when we finally, after a month of lawyers not discussing this, we finally came to terms with the fact that the notice of violation either had to be issued, or the town was going to have to go to the property abutters and tell them that we're not acting on this notice of violation.
You know, the consent agreement is only needed if laws are being violated. You have not proven that any laws have been violated. And we believe strongly that we have not, right from the beginning, violated any single law in the town of Boothbay. Okay, so, and my attorney tried to point that out to the town attorney and asked for a venue for further discussion, and then our consent agreement, our notice of violation was issued right after, with no warning, after our request to talk more. You call that the last resort? I don't.
I would look at the information that we
close to
provided.
the last resort. We've been proactive with the town for the whole time, and this is what we've been given.
Well, I have to say, I'm disappointed that Mr. Stimson and the town haven't been able to work something out in the interim. But that being said, the town feels very strongly, the code office side feels very strongly that Mr. Stimson is in violation. As Mr. Stimson just eloquently said, he feels that he's not in violation. Folks, that's what we got the Board of Appeals for. They will make the ultimate decision. Unfortunately, this board doesn't have that authority. And I'm sorry, I can't help you out.
Sure.
Martin,
Jack,
then Bruce.
I'd like to ask, in their opinion, what is the violation so you can explain it up to me, because I'm down. Okay? Is the violation that the boat building part of it is what you're going through?
From looking, I can tell you from looking at the ordinance, Martin, when I started seeing on Channel 6 and reading in the newspaper everything that was going on with Mr. Stimson, I looked it up. In the definition of maritime activities, I believe is the term, it states right in there that boat building is considered manufacturing.
Okay.
In the general
But it
residential
doesn't, it's
area,
only as a
excuse me,
principal use.
excuse me, let me finish, please.
Yeah,
In the zoning ordinance under general residential, it says manufacturing is not allowed in that zone.
okay, and I like that. And that was the date of 2006 when we adopted these ordinances?
2002 is when that definition.
2002. So anything that was being done on that property prior to 2002 would
Anything,
be accepted?
anything that was done on that property, on that lot, prior to 2002 would be considered a grandfathered use unless that use ceased for a minimum of 12 consecutive months. By Mr. Stimson's own admissions in the papers, and even in the letters to the editor that I've seen, Mr. Stimson ceased for a 24-month period. Once that happened, over the 12 months, it ceased to be a grandfathered
Okay,
use.
so there's no...
But this is all stuff that can be argued before the board.
Well, we all realize that I lived there for 24 years, and them boats was there on that side of the road for 24 years anyway. Okay? If one of those projects hasn't been finished in the last 24 years, how can you say that he ceased? It was still there and not clearly done. I mean, I've got projects over the woods, I never got that. But it doesn't make it not a boat. Okay? The other thing is maybe instead of being 1 year, this should be a 5-year term. If that piece of property isn't used, it should be changed within 5 years. I mean, we're watching it happened over here across the road. I think that Steve himself was involved in that cafe, that they came in ahead of time to get the permits and everything because they were gonna lose their year on it. I think you got one that's maybe gonna happen up here. Bo Brewer's asking for one
We've,
up there on his property.
we've consulted with Bo Brewer and told him that it's in his best interest to get an extension from the planning board so he doesn't have to.
But
go
then
through
there
that
you go
process.
again, is that Bo's or is it his daughter's permit?
The use goes with the
The
property.
use of it is whose?
Use goes with the property.
Yeah.
So if you buy the property, you buy the use.
You buy the use.
Right,
But
so in that
that's
case,
pretty
Bo
good
Brewer
for
has
the
bought
person that
that
had
property, he's bought the use, and it's in his best interest because he's trying to get fired, that he retains that use. So we've counseled him and told him, you should go to the planning board and at least just ask for an extension of that use. Or he's gonna have to go through the full review process, which is sometimes cumbersome. And let's just say that Mr. Simpson's use is an allowed use. More than likely, it's gonna be a planning board reviewed use. That, it still hasn't gone through that review as well.
Okay, now the other thing is with our last code enforcement guy going out, and like you said, I don't know why, all of a sudden you found somebody else, which I think the other person that I noticed was you, was the acting code enforcement guy that brought this to light?
I was just a deputy. I was holding it together until Art could take
You was the
over.
one that brought it out, the guy before didn't take it and run with it. How long of a period of time had he known about it, that you was talking this issue over, before you had to go get the next person? Are we talking 30 days, 2 months, 3 months? I see August 15th on a planning board issue a while ago with, I think it was Eric Madden with some lady down to East Boothbay, wanted to put a 12 by 12 deck non-conforming use, and you stated at the point that if the old code enforcement officer issued that permit, that it was a good permit, even though it was in violation.
That's correct.
Okay, so is this the same deal?
The permit is still
The permit
valid.
was issued, at the time it was issued, he knew it was a boat, the boat part of it was there, because it's been going right along, and now all of a sudden, you found somebody that came out and says, okay, we read it the way you did, but the guy before you didn't read it. These ordinances, I've done it myself. For the last 10 years, I fought half of these ordinances, because I don't think they're fair. If I had my way, along with a whole bunch of us, we'd be in here petitioning you to do away with the zoning ordinances back to 1973, and it's starting to bring them up one at a time. All they've done is make enemies of neighbors. That's what, and when these people come in here and they buy into a housing development, and they sign all the rules and regulations they want, and then they bring it to the town, this is what the natives and everybody else don't like.
You'll see at the Board of Appeals that our legal counsel will show up and they will represent the code enforcement office. And the first thing that they'll get into is that they counseled the code enforcement officer in September of 2011 that this was a non-conforming use. So whether the
Since
code enforcement,
2011.
what's that?
Since 2011.
That's correct.
And he was the guy that was getting paid, and since 2011, he felt that he wasn't in violation.
No, the code
Now,
enforcement
the code
officer.
Code enforcement person, CEO, has got how much time in training of code enforcement?
I don't understand the question.
How much training did that code enforcement officer go get over this time prior to 2011 and after 2011? And he still felt that Mr. Stimson was in violation, but
The code enforcement officer never weighed in on the notice of violation, which he was told by legal counsel was in non-conformance. So he
So
never,
the
he
code
never
enforcement
acted.
officer didn't find him in non-conformance,
He
legal
didn't
counsel
act.
did.
He didn't act on it.
The council acted on the non-conformity, not code enforcement.
No. Nobody acted until the notice of violation, which is just recent.
Statement in and of itself.
There was a lot of discussion about whether we should act, and a lot of discussion about when we will act. And Mr. Simpson was aware that we believe that this to be a violation of code.
I think we're starting to argue some of the facts that should be argued before the appeals board and not here and not in the press.
You've made up your
Is the town-
mind. David Stimson's out of business completely.
The gentleman behind Bruce was.
I'm Ron Fincher. Back to the continuous use thing. Anybody that's worked around boat building understands that it's a bit of an itinerant job. David has never ceased to boat build. He had other jobs in other locations for a while, but there were boats on that property since I think about the 80s. So he has continuously been building boats and doing boat building, and I know that he was continuing his business of selling plans and doing other boat activities from that property throughout that entire period. He's never ceased to do that. Pick up an issue of Wooden Boat Magazine, and he was running ads throughout that period. So he never closed his boat building business, even though he did, to make a living, take employment wherever you could get it. That's what boat builders do.
I believe by Mr. Stimson's own admission in the Boothbay Register, he ceased building boats for 2 years on that property. So I would disagree with you, sir. Alex?
Yeah, I agree that we're starting to argue these points that maybe should be argued in another venue. I would personally petition the town to put the consent agreement back on the table. If somebody had done that to me, it would have made a world of relief until I could have been, gone through the due process. I just got lucky. I happened to be in the right zone when it happened to me. But what I would like to point out, we have rules. We've got them. We've got ordinances. We've got rules. We gotta follow them so we can all get along. We don't have people taking advantage of them. We get the reason why there's rules. We might not agree with every rule that's out there. I get that too. And I think you guys work very hard in doing what you're doing. I definitely feel for David. It happened to me. I mean, geez, in the 90s, I woke up and there's an industrial park next to my property. Nobody gave us some money and said, oh, here, your property is worth less or worth more. It was just there. We agreed upon it. That's it. It's there. It's ordinance. It's law. It's how we agree to live. And I just think that, not to point you out, Martin, but you pointed yourself out, it's great that we have these things, but we have to be able to read them and understand them. I have countless come into the help of Jim and a lot of other people in this room and Art and some of the old code enforcement officers. I've had to talk to them. We literally had to read the thing out to each other like 4-year-olds. Like, what does this mean to you? Speak it out loud to me and I'll tell you what that meant to me and then we'll say it back and hopefully we get somewhere and hopefully somebody wrote it down and put it in a file. And I know these guys only have 40 hours a week to put something into a file and get everything perfect. And it's not going to be perfect. We're going to run into these things all the time. But I can guarantee you, David was not the first, and he won't be the last. And where do we draw the line? I mean, I started my business out of a van and I had slept in a couple times. You know, people started their businesses out of their garage. They get an idea and they run with it. Where do we put the limit down? I'm sure David's not going to be building huge steel tugboats over there, but what's the definition of boat building mean? You know, like I like wooden boats. I love wooden boats. My family's built more wooden boats than all the Hodgsons put together. You know, what if somebody puts up a huge, we're gonna bring back Knickerbocker Ice Company, say, oh, I wanna be a Knickerbocker Ice Company? I mean, we have rules. We like this. It just needs to be a simpler ordinance. Now, I'm not saying take away rules, taking away the guidelines. There might be 1 or 2 lawyers in here who can understand that thing and argue it in a court of law. The rest of us are trying to just argue it on a vocal venue in society. We just like to be able to understand what we're reading, what we're doing, where we live, and what the rules are, and just know what the rules are. To say that this is the ordinance, you should know this. It's like handing an American a Chinese instruction manual on how to work on a VCR. And I support all these things. I support rules, and I support the ordinance. I just think it needs to be clear for us as individuals in this town. We're not a whole town of lawyers.
I'd agree with you there, Al.
Where do we go from there? I'm sorry to interrupt you. Where would we get somewhere? Where would the process be to get that simpler and changed?
In this case, and I'm just going to speak for myself, these guys can weigh in. I'd like to see Mr. Stimson work with Jim and work out a consent agreement so that his guys can get back to work in the meantime. That being said, and I thank you for the applause, I do not believe that this board can overturn the notice of violation and just say, go back to work. Something needs to be worked out between Stimson Boat Building and the town of Boothbay. In the meantime, if Mr. Stimson wants to get his people back to work, we can't just thumb our nose at the law. I feel for Mr. Stimson, I do. It pains me that he and his crew are out of work. But the town of Boothbay also has a job to do to enforce the rules that the townspeople have told us that they want. We've run into something here that needs to be looked at in the future if the town wants to change it for the future. Have something written up, have it go before the planning board, have them recommend it to this board to recommend a town meeting. We can't do that right now. And I will tell you, it's not a quick fix. It takes time. Lots of meetings, lots of process.
I'm sorry, Mr. Cunningham, you weren't implying that Mr. Stimson was thumbing his nose at the ordinance, were you?
No, I said the town cannot thumb his nose. And, sir, I'd like to say I appreciate your passion, and I'm sure that the people of Bowdenham appreciate your passion on the planning board as well. We haven't had someone who comes in with a passion for ordinances like you in a long time. And I'm sure that Mr. Stimson is grateful to have a friend like you. Mike.
Mike Tomaselli, resident of Vernon Cove Road. 4.5 years ago, I purchased my property on Vernon Cove. For 2.5 years, driving by David's property, I did not see any activity on that property. My wife, myself, all of the residents on Vernon Cove Road. This is not just about one person. This is about the rights of residents in this town and people in Vernon Cove Road. And as far as I'm concerned, if I had known that there was going to be a boat building operation there, I wouldn't have bought there. Other residents would not have built there. If I wanted to be near a shipyard, I would have moved to East Boothbay. I worked in a shipyard for 7 years, but I made that decision not to do that. I wanted to go into a neighborhood. And none of you have experienced what we have experienced in that development. When you drive up and down that road or walk up and down that road while construction was going on, and you hear hammers swinging, pounding steel, I know what that's all about. That's pretty noisy. And ventilation fans generating noise. That's not why I moved there. I had no intention. If I had known that, I would never have been there. Number two, a week ago this past Sunday, I met with David, and I offered him a way to go back to work.
Why do you have the
invited him into the industrial park. I said, why don't you come up into the industrial park? There's boat building there, there's yacht refinishing, there's marine repairs up there. It's an allowed use in the industrial park. And I even went to the extreme where I said, I'll finance property to help you out, to help you get back to work. So there's another side to this whole story, and it's about rights of people in this town who live in an area who had no idea that there was anything going on there. And then all of a sudden, a year and a half, we start to see projects start up. And I'm sorry, that's the way I feel, and that's the way the residents of Vernon Cove feel also.
And you're about the only ones in the whole town that come forth in that regard, I think.
No. I just stated a minute ago, I completely support that. Like I said, I woke up one day and there's an industrial park next to my house. It grew little by little by little, but the law was there. It's made a huge difference to how we live and how we focus our property. I totally support the residents. I support the rules and I support these boards here. I'm very supportive of it. I would love to see you go back to work and work this out. And I'd love to see the town put that back on the table. I can't believe the town even made a consent agreement. That's amazing. We've never seen that out of this town before.
No, we've worked out agreements with folks in the past.
I think that's amazing. I think it's amazing that we can go that far. And I'd like to be able to see it get done. I don't want to put anybody out of work, but I really feel for the residents too. What I'm talking about, my whole pitch was that systemically, the ordinance is very confusing. And it's easier to sometimes just, I did it, I tiptoed around it thinking I was fine, and I wasn't. It took somebody pointing it out to me, and I got a notice of violation. I was shut down. I had to go through due process, and it was terrifying, absolutely terrifying. I was already terrified about the bills I had to make that week, let alone, my company got shut down. And I was in violation. I looked at the rules, and I was like, oh, how could I be so stupid? I was in violation of a lot of them, but I was naive. I couldn't understand it. It was simple to look at this one and say, over here, oh, well, that's on page 74. I got this right here. Okay, that sounds good. And this is what David's got. He's got one over here that says, oh, this feels good. That's what I'm about. That's what I'm doing here. I'm doing the right thing. And sometimes it's not. And I understand we're all working towards getting away from nonconformity. And that's the whole direction of this. But it'd be a lot simpler if everybody realized what they were doing, where they lived, and what was going on, and it was easily presented to them. It's like there's no... I just did a test. I asked 20 of my friends, so where do you live? What zone are you in? What are your allowed uses on your property? I got the dumbest looks I've ever seen. It's like, oh, I'll just put a garage up and start a lawn mowing business. It's like, no, not over there, you won't. It's not like somebody's taking it away from them. They went and bought there not knowing. I don't even think they knew where to go to know. I think the town's moving in a good direction there. The information's on the website now, but it's still complicated information.
Chuck, would one of the issues that the big thing would have been this being a steel boat versus a wooden boat? I mean, it's like Mike says, ironworks is a whole lot different than woodworks. I mean, a lot of times you will buy somebody's house and if they're working with a piece of wood, you don't hear it. But if it's a piece of steel.
Unfortunately, Martin, the current ordinance doesn't differentiate between steel and wood. It just
But I mean, with the neighbors themselves,
manufactured.
would the neighbors themselves, would they be complaining if it had been a wooden boat versus a metal boat? I mean, they might not have even heard it a word. Mike can attest how loud it is. I agree with you.
Yeah, and I told Mr. Stimson that my own perspective is that he could have probably built wooden boats in the barn that he was previously building wooden boats, and it would have never come to anybody's attention that it was not in compliance with the law. It was when it started affecting other people that they pointed out, hey, I don't think this is right, and then tasked the town with investigating. Now, I can tell you that I've personally been, this has been tough to see the town struggle through the identity of itself and what laws are there and how do we enforce them. The town, I feel that we're enforcing the letter of the law. I think we're doing what is legally right. Does it always feel right? No, it doesn't feel right. And the town needs to figure out, are these the laws that they want? And they need to figure that out at a town meeting in a legal venue at a future date. At this point in time, that is the law. It's been pointed out that it's not in conformance, and the town has a legal obligation to act on it.
Mr. Stimson.
So, the town hasn't actually been able to to show that, to demonstrate that it's a non-conforming use that we're doing right now. It says right in the ordinance that the construction of boats as a principal occupation is a manufacturing use. Now, that's not my principal occupation. Boat repairing, I can show my past records. Boat repairing, by far, has been our bread and butter. And we boat builders, we do a fair amount of repair work. Once in a while, we get lucky and we get a boat to build. Now, we could go 3-4 years without getting an order for a new boat. Does this mean we lose our grandfathering for boat building? No, it just means that our use for the property is intermittent boat building. That's just how the business works out.
The trouble is, you're not in the commercial zone.
That doesn't matter, it says right here.
Doesn't make
Principal
any difference.
occupation.
You cannot, I don't care, occupation or not, you've got to be in the commercial zone.
But that's not what it says. If you look carefully, it's not.
David, I'd have to challenge you on one statement that you made, and that is, after you finish that steel boat, if you were allowed to build boats and somebody came to you and said, I'd like you to build 4 more, you would not turn that work away. You would build 4 more boats. Anybody in their right mind would,
Mm-hmm.
right?
But,
Yes, the answer is yes, there's no question about it.
okay, there's no time period given in the ordinance for how it doesn't even really define principal occupation.
We live
There's
there,
no-
that's our
we
principal
live-
occupation.
The principal use of the property is as a residence, right?
Not right now,
And
not
there's-
with what's going on
and
there
there's
now.
as the principal occupation, they don't define it, and they don't give a time period, okay.
Are these 2 separate lots?
No.
No.
The road divides it, makes it 2 lots,
No.
right?
No.
That's right.
We bought them as one lot.
Right, right on the map, it's two.
We
Town
have
tax
the
map,
deeds.
it's 2 lots.
It's
Right.
two lots.
So if I build 4 boats in 2 years, but I've done boat repair for the past 8, it's still not a principal use, you know? Where's the time period that defines what?
I think it also states in there that any secondary use has to be allowed as a principal use, or the secondary use can't be allowed. I think that's in the ordinance as well.
There's 2 reviewing authorities in the town of Boothbay. There's code enforcement, who reviews uses that are permissible for code enforcement to authorize, or allowed uses, which they review to make sure that they are allowed uses. All other uses need to be reviewed by the planning board. At this point in time, code enforcement has reviewed this use because it doesn't specify that this use is reviewable by the planning board. Code enforcement's interpretation is that this is not an allowable use. So the only reviewing authority that's heard this is code enforcement. Now, I understand your arguments, and your arguments, I'm not gonna say are bad, but they're for the appeals board.
Okay, but just pretend for a minute that we're right. Number 1, that we're grandfathered, and number 2, that it's not a non-conforming use. I will have lost at least 8 weeks worth of work without having anybody but one person in code enforcement and you decide what the interpretation is.
How many people do you think work in code enforcement? I mean, we have a town staff of 12 people. 6 of those are public works employees. I mean, ordinarily, there's 1 person in code enforcement.
All I'm saying is that it's entirely possible, and in this case likely, that we are being punished for not doing anything wrong at all.
The Board of Appeals is the appropriate
Right.
place for that to be
Then
decided.
and so if we turn out to be right, do we get all our money back? You know, we'd have to go through a lawsuit to do that.
That's correct.
And that's if we survive for another 4 weeks.
I'll take 2 more comments. I get the gentleman in the sweater.
Yes. My name's Mike McConnell. David built my boat in 1986 in his mother's barn, which is across the road. Then David built his house on the same property, which is owned by Mrs. Gillard and Bob Gillard. It's, as far as I'm concerned, if you look at Wood and Boat and you check the ads through all those years, Dave has been an active boat builder. He might not have been building, but he's been actively putting out his boat building business. I strongly recommend that the town manager and David take your recommendation of working out a new consent agreement and try and get these guys back to work.
Thank you.
Yes, sir.
My name is Bob Foster, and I arrived here when I was 2 weeks old. And I started building boats in my backyard, or at least repairing boats in my backyard. And I at age 72, went to work for the Boothbay Harbor Shipyard, and I watched David, as president of the yard, build a yard from nothing up to a yard where we employed 52 men. It was a great boon to this community. The idea that we're even having this discussion in a community where one of our emblems is a schooner is to me absolutely ridiculous. When a man can't build a boat in his front yard, it's absolute nonsense. If Chetley Riddle were building a boat in his front yard, we sure as hell would not be having this discussion. I beg you to think about how ridiculous you guys are gonna look if this thing goes to the mat.
Well, actually, since you bring up Chetley's boatyard was located in Boothbay Harbor on the water.
Chetley also built boats in his front yard.
Yeah, and he's not, that's not residential, that's C1 or C2.
One of those boats is in his front yard right now.
Last one, Bruce.
Sure, thank you. I've had my hand up for a while, but trying to obey the rule of law here myself, putting my hand up. But I want to commend the board for this, allowing this discussion. I've been in other boards where, you know, people are shut down before they can really have a good discussion. I commend you for letting everybody talk. But I would like to ask you specifically, if you could separate out, let me make a statement. I think that because they've been forced to stop work, it's as if the town has already decided that they're going to prevail in the appeal. It's as if the appeal had already been done and that the Stimpsons lost. I think the only fair and compassionate and just course is to let them resume work until that appeals process, over which they have no control, can happen. Let them work. It's not going to, I mean, really, is it going to hurt anybody to let that happen? It's not going to hurt the rule of law, because the rule of law is taking place as we speak through the appeals process. Let them start working again until the appeals process takes place. And then secondly, so I hope that you will take under advisement and come back to the public with a statement as to whether you can separate out the appeals process on one hand from the cease and desist order on the other, and let the cease and desist order lapse and let him go back to work while the appeals process goes forward. I would like to see that you make a positive commitment to come back with an answer as to whether you can do that or not, and as to what your answer will be. And then secondly, I'd like to ask, I realize I'm going on, but are you in a position to recommend to the zoning board that they come forward for the next town meeting with a clarification of the language that's caused so much pain and confusion on this issue, and ask them to come forward with it to you and then put it on the warrant for the next town meeting? And thirdly, I think the Stimpsons have the right to go out with a petition to get a special town meeting if the board is not going to go in that direction. So that's another option that I believe they have open to them, is it not?
Okay. Two things. By me saying that Mr. Stimpson and the town should work out a consent agreement, if they can work out a consent agreement, that puts them back to work. I am not comfortable tossing that notice of violation out and letting them just go back to work.
That's all I was asking.
I'm not through. The notice of violation was issued from the code office. The board doesn't get into the aspects of that until much later on, if it's needed at all. If Mr. Stimpson and the town can work out a consent agreement and get his crew back to work, so be it. Until then, there is also the matter of the Board of Appeals appeal on November 1st. Sorry, but I would not vote to say, go back to work even though you have a notice of violation. That's just not right. That's, would be the board thumbing their nose at the NOV. And the town feels strongly through legal counsel and the code office that they have a reason to issue that notice of appeal. We cannot overturn that. Now, like I said, I feel badly for Mr. Stimpson, but in my eyes, his best recourse is to work out a consent agreement with the town. I'm not sure what was in the old one. I'm not sure why it wasn't signed. That's between him and the town.
Could I just second?
As far as a change in the ordinance, that can happen. It's going to take time. That proposed change would not come to this board. That proposed change would go to the planning board. They're the ones that would take a look at it and decide if it's a good change for the ordinance and would recommend it to us then to recommend a town meeting. Yes, they could have a special town meeting. However, that's still not going to speed up the process. If they started now on a possible zoning change, it would take that long to get it to May. So a special town meeting would serve no one. It wouldn't serve them, it wouldn't serve the town. So the answer to your question is yes, they could have a special town meeting, but it's not going to solve
Are
it.
you certain that the notice of violation must include a cease and desist?
Whenever a notice of violation goes out, the wording, and Jim can speak to this better than I, states right in it, here's your notice of violation, you must cease and desist immediately. And I believe that's standard language in all notice of violations, not just Mr. Stimpson's. Dale.
Well, the only thing I want to say is everybody keeps on talking about due process, and it's our responsibility. And the last thing I want everybody to think is we're all sympathetic to you. Everybody here. We all live in that
I don't believe
that at all. You have showed no sympathy at all. You have
Okay.
shown none.
Except to your process.
Exactly.
Right.
If we don't follow the process for the, if we make an exception for the Simpsons, and then do we make an exception to everybody that comes before the selectmen and we step on the Board of Appeals?
Yes, if they're hungry and they can't feed their family, their wife, and their children, absolutely.
And their employees.
And when you look at the logic of the issue, okay, this is not a manufacturing, this is not General Motors. This is a boat builder that everybody in town understands boat building and boat building in your backyard, and sometimes you
Okay,
get
let's talk
lucky to
about
make a
it,
business.
but let's talk about everybody in the town. Does everybody in the town know that the moment that we release it, that general residential can allow boat building, steel boat building in their yard? That's town-wide, that's Barter's Island, that's every place.
We're not asking you to release it to everybody, we're asking you to release it to him.
You can.
To let
But
him
if you
build.
change
Mr.
the ordinance, it's
Simpson
gonna
should
be.
get together with the town manager and the code enforcement then and get a consent agreement. It's as simple as that.
And
All of
that's,
this is a moot point.
it really is. And one thing I want to state about this board is we've allowed people from Bodenham to talk freely. We want people to have an input on, we've never shut anybody down from voicing an opinion. We always encourage them to resolve this long before it ever gets here. We're taking the appeals process and throwing it to the wind as we allow this discussion to take place in this meeting.
But it doesn't seem
But
like
we're
it
still
reflects
trying-
on any decision that you make.
We can't, it's not within our purview, we can't do anything.
We can't open up a.
The process doesn't allow us to.
Pandora's box and everybody do what they want to do.
I gotta
And this
say with the
is-
select board on that one, the appeals process is an independent process and they cannot legally in any way, shape or form involve themselves in that process.
And just by having, but just by having this discussion, we're already kind of clouding, everybody thinks that we've already made a decision. We're not even supposed to know what's going on, and yet it's been all over Channel 6, it's been all over the front page of the Register, and it's been all through our meetings.
And it should be.
That's true.
I feel for Mr. Stimson a lot. I've lived there all my life, everything, but look, we're only talking like $1,000 to pick this boat up and stick it on a piece of land that would not be in violation. You can put it into the industrial park. It's my understanding you don't even have to have a permit to go to the industrial park for boat building. I think that if Mr. Stimson wants to keep his business going, he needs to do the right thing and maybe pull that boat, put it somewhere where he can continue it, keep people working, that if he's concerned with those guys having a living, and fight the process the way it has to be fought, either through the town or through the court system, but he needs to put the people that are working for him and think of those people first and start working. And if it means moving a boat on a trailer, that's up to him. And if he's not willing to do that, to get his people back to work, it's not all of our problem. It's our problem the way the rules and regulations are. But he can still put those people to work tomorrow by just calling a boat person up with a trailer. And probably, I bet you, because I've worked with most of these guys in the area that work in the boat building business and move stuff, they probably feel the same way as I do. And I wouldn't be a bit surprised that somebody would come forward and transport his boat for little or nothing. And I wouldn't be too sure that somebody would give him a place up in the industrial park, reasonable, if not for free.
This is
So
about,
there's a way for him to get out of it and fight it the due process.
this is about a man and his property and his right to build a boat in the state of Maine. Simple as that.
Well, we all voted, this ordinance didn't just show up one day, we all voted on it. So if you didn't pay attention and you didn't vote, this is what you get. And I'm just saying that, on top of that, it's really freaking complicated. There's a lot of people who don't pay attention and show up to vote because it's too complicated to figure out.
Yes.
It's got a lot of
If I
money in
read
order.
this, you've directed the town manager to work out a consent agreement, as long as you put an indication on there that it's a rational one that someone could likely sign, not a drop dead clause. If you're encouraging them to work out a reasonable agreement that he could likely sign, then I think you've done the right thing, and I'd support.
I didn't agree with that. I didn't direct the town manager to work it out. I suggested that Mr. Stimson and Mr. Chaosis get together and work this thing out. We didn't have a vote of the board, so he wasn't directed. It was my suggestion that they work this thing out. Like I said, I didn't read the first consent agreement. I don't know what was in it, but I would like to see them work something out.
2 weeks ago, there was only 3 of us here, and we again encouraged Mr. Stimson and the town to get together and hopefully be able to work something out as well. This board has repeatedly said we'd love to see it resolved long before we ever see it in an appeals process. But yet we keep on getting roomfuls of people and we understand public opinion on this is very, very strong, rightfully so. Fix the ordinance, change it, whatever you'd like to do, but you gotta go through the process in which we've given you to do so.
Meanwhile, David goes bankrupt.
But David has another option that he could take as well, and if it means changing some wording, well, maybe we should have been working on changing. We've had since September of 2011 to change wording.
The town issued David a legal permit to build the boats there.
No.
No, they didn't.
Just a barn.
Well,
No.
Just a barn.
a building.
With the intent to.
But are you saying the code
But they-
enforcement officer thought he was gonna raise chickens in that barn or something?
You can't just give him a permit to, you gotta get a business permit, it's a planning board's job. I sat in front of the planning board, I thought it was beautiful. What time are you open? What are you doing there? What materials are you gonna be holding on the property? Who's taking care of your waste? And you had to put in a plan, you filed with the town.
A butter notification.
A butter notification.
Unless it's determined by code enforcement that the process is grandfathered in and the process to the planning board is not considered necessary by code enforcement. At that point, that's the end of the story, and that's where David wound up. He was not in violation of anything. The code enforcement officer at the time considered his activity to be grandfathered and didn't think it necessary that he have to go before the planning board to get his business permit.
Jim, do you have one last comment before we
Well, I
close
mean,
this?
the code enforcement office is not being heavy-handed. While we were down there, there were several unpermitted buildings that we told Mr. Simpson, please just apply for permits or take down the building. We don't want, we're not looking for violation notices here, we just want compliance. We haven't split hairs over the fact that an occupancy permit has never been issued for the building. We don't care, we want compliance, we want this as close to compliant as possible. So, I mean, there's a lot of variables here that the town just wants to look at the large one, the one that is causing the most harm, is the fact that we think that this is not a conforming use. That needs to be flushed out. Now, we did tell Mr. Stimson that we'd be happy to work out a consent agreement. Now, think about who works out the consent agreement. We're talking about the code enforcement's authority to work out this agreement that says we will not pursue a violation. Well, at that particular time, I was working as the code enforcement officer while we were trying to patchwork together code enforcement services. Well, after that happens, there's a freedom of access request. Well, who's that go to? The public access officer. Who's the public access officer? I am. I have to deal with that in its own realm. And then we have an appeal. Well, who sets up the notifications for all the appeals and rounds up all the Board of Appeals members so we can set a date? Normally the town manager, who is not acting as the code enforcement officer. We're blending these lines. The most important thing to the town is that the appeal is heard and is valid. So I'd be happy to step back and say, okay, we're clear, we're acting on the code enforcement officer's authority right now in this room as we discuss back and forth an agreement. But as long as there's freedom of access requests, engagement with the Board of Selectmen, which I think is out of the norm, then we can't focus on the fact that a question to work on the consent agreement has been posed and is in its entirety clear. You know, we need to work on one thing at a time. And right now we have an appeal, we have a freedom of access request, and we have a consent agreement and a violation all going on at the same time. We need to work on one thing at a time. If the appeal is the most important thing, then the appeal will take priority. If the consent agreement is the most important thing, then the consent agreement will take priority. But that's up to Mr. Stimson to figure out what is most important.
So are you saying in order to facilitate a consent agreement, he has to withdraw his appeal?
No.
So if he leaves his appeal process in, you're refusing to continue the conversation on the consent agreement? That's what I'm hearing.
I told Mr. Stimson the same day that we were working on the appeal, the freedom of access request, and the consent agreement, that the lines were getting blurred. At some point in time...
So because he's following through with due process on appeal, you're refusing to continue conversation on consent, is what I'm hearing you say. Is that correct?
The consent agreement is at the purview of the code enforcement officer. It's not something the town has to do, it's something the town wants to do.
Okay, but what I'm asking you, is that correct? If he continues, because he had to do his appeal in a certain period of time, if he continues to allow due process under the appeal, the laws of the town for appeal and timing, if that stays put, so he doesn't get himself backed into a corner there, should the consent agreement not go, you're saying you're not able to do a consent agreement. So he has to revoke his appeal and sit with you. Well, this is what I'm hearing you say, that because he did an appeal, because they did an application for freedom of access, and because there was a consent agreement there, something had to get sidelined, and it was the consent agreement.
There are only so many hours in the day. We have to comply with the freedom of access request in the amount of time that law gives us. It's not like I could postpone anything.
Well, so it's the same as he did with the amount of time the law gives him in the appeal. So you both have certain time constraints that you had to do certain things. The one thing that's left on the table that gives you both an opportunity to converse and resolve is a consent agreement, and it's the one thing you're saying that you don't have time.
Which I drafted an amended consent agreement, sent it to Mr. Stimson for his comments, and haven't heard back on those comments yet. So I am more than willing to sit down at a table and have a back and forth conversation. But if it's going to draw...
I'm sorry, did you not state that because of the circumstance under the appeal that the consent agreement would not be discussed?
No, I think what he said was that he had all of that on the table. You're talking in circles.
There is some documentation to back up that my last statement to your town manager, by the way.
I gave the consent agreement, an amended version of the consent agreement, which I expected comment on. I expected David to say, I don't like this, I don't like this, I like this.
So when he asked to discuss it with you, and you said, under the circumstances of the appeal, I refuse to discuss this anymore, we're just taking it to appeal? What is that? Was
In the
that
meantime, while I was waiting for his comment, we got the freedom of access request in the appeal. We have to act
So
on it.
then you withdrew the consent agreement at that time?
Because we
Not
don't have
David,
time.
you did. So you didn't actually get a chance, when he requested to sit down and talk with you, you didn't actually get a chance to sit down and talk because you withdrew the request to talk.
Right.
Correct.
Okay, so just making sure I got the facts
think
straight,
the
so I'm
town
not
would be-
talking in circles, okay?
Jim, answer this for me. How long between the time you sent the consent agreement to Mr. Stimson and the time that it was taken off the table? What was that time period?
I'd have to go back and look at my computer, but I mean, it was 4 to 5 days. I mean, but it was a weekend thrown in there too. I can understand where Mr. Stimson didn't have time to respond, but I thought it was imperative to him that we sit down and discuss it. I thought it was more of a priority.
Does anyone in this room besides Jim understand the consent agreement and the number of, what is involved in that? How many pages and how thick that is?
You mean, has anyone else read it? Yeah,
No.
there's quite a few folks that read it.
Oh,
I read it.
Yeah, there's quite a few folks that have read it.
I read it.
That's why we understood that it was a drop dead situation and not a resolution.
It's
David was agreeing to something that no reasonable person would agree to. If it allowed for the appeals process to continue and follow through while this thing went on, rather than you get this,
You
you get
talking
this.
about the
and you're
consent
done.
agreement?
Pardon?
I said the freedom of access request.
Oh, you said consent agreement. I'm sorry.
I did?
Yes.
Yeah,
Sorry.
you're talking.
No, I'm talking about what you said.
circles.
He got, that's good coming from you, John.
Yeah.
This is all so ridiculous.
Well, there's a lot of folks that
I would encourage Mr. Stimson and the town to see what they can work out in the meantime.
Thank you. That's exactly what
In the
it is.
meantime, there is an appeal on the
Yes.
table that will be heard on November 1st.
Thank you. That's right. Thank you. Thank you.
And you've been able to comply with the freedom of access request.
Yeah, it's ready. We've already sent our correspondence.
Sounds like there's time for consent.
How soon, Mr. Simpson, would you be able to sit down with Mr. Chaosis?
Tomorrow morning?
I think I'm ready first thing.
All right.
I don't want to promise time that I've already promised to somebody else, but I think I'm ready first thing.
Can we all come?
I don't think that would be negotiating a good thing.
That would be confusing.
I'm ready first thing.
Thank you.
We open at 8:30, but I'm here at 7:30, so.
Now, I can be honest, I know the town attorney isn't gonna like this meeting. How's your attorney gonna feel about it?
I think he would be happy for anything that would allow us to come to any kind of resolution that would mean that we wouldn't, the town and us wouldn't have to waste the time and money on an appeal. It may be that we can come up with an agreement that would allow us to drop the whole appeal.
So would you be able to have your comments on the consent agreement to Mr. Chaosis tomorrow morning?
So, the only sticking point would be how soon I can get in touch with my attorney. But I think we could talk about general things and then come up with specifics through the attorneys.
What about the old consent agreement didn't you like, specifically?
And honestly, the
Put
first.
that right down and tell him what you don't like. Maybe you can work that out.
Yeah,
But if you have to start a new consent agreement all over, you're
yeah,
talking a lengthy period.
right.
And if you want to get this resolved quickly, a new consent
No,
agreement
I
is
think
going to do it.
that's worth pursuing.
I have to say that Mr. Stimpson and I have discussed the consent agreement, and like I said, we drafted all the dates that were in the consent agreement on the hood of my truck. I thought we were being amicable. The first time that I heard that they were unreasonable terms was when it was on Channel 6. That was the first time I heard that statement. I heard that you didn't like the terms, but unreasonable, I never heard that.
I had my back against the wall at that point. I had not had any legal counsel at that point. I didn't know at that point how I stood legally. I kind of, I'd been beaten into thinking that I was in violation, which I'm quite sure now that I was not in violation of anything. So that's, my position on the consent agreement is different now than it was when I was almost willing to sign it.
And the amended version that I sent to you was without our legal counsel. I told you that I was going
Right.
to work on it and that you and I would work on it back and forth. When I sent you that copy, you said you were going to bring it to your legal counsel. At that time, I did think that it wasn't you and I discussing this anymore. If you want to work it out and then ask for your legal counsel's opinion,
Okay.
which is the same thing I would do.
Yeah.
I'm not going to enter into a contract that I haven't sent before our lawyer.
Right.
But I don't have any problem working out the terms of that, you and I, and then figuring out what the legal jargon is to make sure that that holds up.
Well, let's get to bed, you're gonna be busy in the morning.
That sounds great.
That sounds great.
Let's go.
Thank you very much.
I just want to thank the board so much for letting everyone talk. It was wonderful.
What time would you like to be?
I have something to
All right. We'll move back up to approval of minutes of the previous meeting from 9/24/2012. Second. Motion's made and seconded. Any comments or corrections?
Just that one on the bottom.
I've got it.
Okay. All those in favor? Motion passes 3-0. Steve and I weren't here at the last meeting, unfortunately.
You want this open?
Yes, please.
If you're quiet out there.
Next under,
Yeah, you're quiet.
next on the agenda, public comment.
We had enough of that. Oh, swept out there.
Later on?
I got one thing to say, Jack.
Okay.
Thanks for putting that in the Pledge of Allegiance. Tried to make it the first night, but I had something going on.
Well, I wish you would, because we forgot it.
He forgot it.
Yeah, and actually, I think I have to take responsibility because late tonight, I walked in late, which threw off everything, so I think I have to own responsibility.
So was this the first night?
Yes.
This was the first
Yes.
night.
So you made it to the first.
Reports, Jim.
First, November 6th election. Reminder that there's state, federal, and local questions on November 6th. Absentee ballots are available on all the questions now. We've got the state and federal absentee ballots just in the middle of last week. So if you called and somebody said that they weren't here, they are here now. Voting has already started. The audit status is the MD&A has been finalized and submitted to the auditor, and today we exchanged some emails. I put in the memo that the second meeting in November would be when we would have our discussion with the auditor, but the irony is the auditor is getting audited at that time, so we're going to postpone it to the first December meeting, and they said the 10th will work for them, if that's okay with the
December
board.
10th?
Yes, sir. Through getting the Board of Appeals ready for their appeal on November 1st, which we've already covered, they'll be meeting to hear the Stimson case on November 1st. This is the first time we've done a Board of Appeals since I've been here, so we're making sure we're going through the letter of the law and notification. So the Board of Selectmen will get their notification sent to their homes. We want to make sure that's done correctly. But we also found that there's 2 openings on the Board of Appeals, a full-time member and an alternate. We're not sure if Estelle will want to move up into a full member, so we were figuring we could advertise for a full member and an alternate and then try to fill those. I don't think it's best practice that we fill it during the appeal, but we can get that notice out so that the selectmen are ready to act on that right after.
This doesn't hinder at all his ability to appeal, correct?
No. There will be 5 appeals
Yeah,
members.
it's 5 plus 2 alternates, and they have 5 members. What I would suggest, Jim, is you get in touch with Estelle before the advertisement goes out. If she wants to move up, just advertise for 2 alternates.
And we will.
If she doesn't want to move up, I'll take that position.
I think you would have to accuse yourself in that.
That's good, baby.
That's a really difficult board to be on. So, but you know, the board members there are really solid. So it'll be nice to get some new members in there to learn, and maybe they'll be even interested in attending. Maybe that'll get some people interested in that committee or that board. In your packets, you received a letter from St. Andrews Community, Lincoln County Healthcare about the St. Andrews Community Committee. I emailed this off to you because I wanted to make sure that it got to you in a timely fashion. I don't really have any comment. I don't know if you do.
No.
The St. Andrews Task Force. The Boothbay Register and Channel 7 have done a really good job of keeping everybody abreast of what's happening with the task force. Just over $21,000 has been raised through donations. The legal aspect of that has been working diligently and will probably be at the point of revealing their progress here relatively shortly. On the next agenda for the task force, I'm going to recommend that we have an executive session to speak with legal counsel. So the next session may be a little bit shorter than we previously had, just so that we can do some strategizing. Chuck, do you want to add anything since you're the chairman of the task force?
No, I think the turnout has been fantastic, and people have been watching it on Channel 7 as well, and the register's been keeping everybody updated. So I can't really add anything on top of all of that.
The hardest part in the task force is that obviously it's an emotionally charged set of people that come out to attend the task force meetings, and anybody that reads the registered saw that I apologized to Stacy Miller at the last meeting. I think I got pulled into the emotion a little bit and probably said a few things that were off the cuff. They weren't intended to be disingenuous or disrespectful, but I think I got caught in a situation like that. But I'll apologize to Stacy at the next meeting. Department head reports. We had a department head meeting today, and I was the only one there. So I'm going to ridicule all the department heads. But under that section, I can get into a couple of things. I did meet today with a firm that does power purchase agreements. Those are solar power panels. Right now, there is a movement, I think it's called Grid Solar. What they're trying to do is CMP has proposed a power upgrade down the peninsula. It's going to cost about, I think, $18 million to provide the amount of power delivery that they want to provide to the peninsula. And in lieu of making ratepayers pay $18 million more worth of capital infrastructure improvements, this Grid Solar program has tried to find other ways to add into the network via solar panels, generators, or efficiencies. So we had somebody come in today and discuss with us about our buildings, if we could put solar panels on there and what cost it would add to the town. And right now it would look like we could essentially add solar panels for free, but we're not obligated to do that at this point in time. But if we do end up signing an agreement, it would probably be accelerated because we're trying to get into that Grid Solar program. So I figured I'd take the opportunity to tell you that I met with a gentleman today. We're going to pursue it like we are interested, and as it unfolds, we'll let you guys know. And then I told Steve, wearing his refuse district manager hat, that they were also interested in some of his buildings. And I know they've spoke with the water district and the YMCA, and so it's an effort that's being pushed right now on the peninsula.
Is this only being extended to public entities?
I think it's, in this particular case, it's easier for public entities with the solar panels, but I know that they're looking for anybody that has generators and anybody that has large scale AC. If you have large generators, I think there's going to be incentive programs to turn those on during peak hours. So I don't know all the specifications to Grid Solar, but if you heard it on Channel 7, I can get those contact information to you. I know the people that were doing the solar panels were only interested in municipalities, nonprofits.
Here comes the negative comments from me again. The CMP upgrade to the grid down through here, when did they decide to do that?
I don't think they have decided. I think what they proposed it to the PUC, and the PUC had started this grid solar project in order to come up with an alternative. So I don't think it's been approved yet.
Would they still recommend that if we lose the hospital? Because I know hospital lines have a higher priority than non-hospital lines for CMP. And if we lose the hospital, will we remain a high priority?
I don't know. I know they had discussions with the hospital about their generators, because obviously the hospital has some pretty high power generators, and would they retain those generators after April 1st? I don't know the answers. And also in department head reports, this is, I guess, me reporting, is that we're starting our budget preparation in November. Usually right about now, I give you guys a timeline, the dates that we have to hit in budget preparation so that we meet May town meeting. I was working on that shortly before the meeting, so prepare for that in the coming meetings. The last thing is this is the enviable part of the year where you get to do the town manager performance reviews. I put the same format that we used last year, a blank format of the town manager performance review, in your packet, so you can start thinking about how you want to fill that out, and we can arrange for a date when you guys want to do that, preferably executive session, so we don't have to ridicule me in public. But November would be when we're scheduled to do. We did it November 11th last year.
I think we're gonna have an executive session at our next meeting at least. I don't see why we can't do it and be done with it. I mean, that would give us 2 weeks to think about it. In years past, if you want to fill out, each of us fill out our thoughts on this, and then we combine them onto one that you have to sign at the end.
Yeah.
Our next meeting would be what? The 30th? It would be the 23rd.
October 23rd.
No, 22nd.
22nd, yes, I'm sorry. We're just planning on having an executive session on the 22nd.
Pre-meeting, after meeting?
After meeting.
I'm not sure, but I think we skipped comprehensive planning.
Okay, I wasn't sure.
Not that I'm trying to elongate things, but.
That's okay. Comp plan?
Did I? Oh, I'm sorry. You're right. I did. Absolutely right. Comprehensive Planning Committee, and it's reiterated in our new business. The Comprehensive Planning Committee got a little bit sidetracked for a couple of meetings due to the task force and the other things that the town's been working on, like the Stimson case. There's been a lot of things that have kind of gotten in the way of the regular comprehensive planning. Got back on track at the last meeting and proposed an RFP for consultant services, so you'll see that next. But Chuck is the chairman of the Comprehensive Planning Committee. Anything to add?
We're working on subcommittees to work on different aspects of the proposed comp plan, and the members that were at the last meeting weighed in on where they wanted to be, and we're asking the members that weren't there what subcommittees they wanted to work on.
Right.
And we're going to give the subcommittees a little bit more leeway so that they meet when they need to work on their sections. But as Jim said, we've got the consultant RFP that we discussed at our last meeting and proposed that we send it forward to this board. That's all I've got.
No, we learned something from the task force, actually. So, I mean, you live and you learn, and we learned from the task force is that these independent groups that don't have, that aren't nailed down by meeting dates and not nailed down by quorums or lots of structure, they have, a person or two kind of peppered into their group, actually get a lot of work done. So we want to allow the comprehensive planning committee to work in a similar kind of structure as best as we can, and still have it in the public light.
Sounds like a plan.
Question?
There's subcommittees as well, like the industrial park subcommittee?
That's a separate committee.
Okay.
But they are starting to assemble subgroups of the comprehensive planning committee. At this point, all it is the comprehensive
Oh,
planning
that's a
committee.
subgroup of the comprehensive plan.
Right.
Okay, sorry.
So the comprehensive planning committee members have all said, I'd like to be on education. I want to be on municipal services, and they've kind of picked out which ones they want to be parts of. And as they try to meet, we'll make those meetings publicly available so people can attend and weigh in. But I don't think we're at the point of bringing in people that aren't on the committee to bring their opinions in yet, and because we don't even actually know who's meeting when and where and what. But you bring up a good point. The industrial park planning committee, which has gotten completely sidetracked from all the other things that we're working on, is another ad hoc committee of its own with its own mission. And we hope to bring the industrial park planning committee into the comprehensive planning committee at some point in time. We just don't know if their timelines meet at the same point.
Because speaking of those timelines, we've lost ours.
Right.
Yes.
Do you think you'll have something ready for this year's town meeting again, or?
No,
Because last year they wanted to get the industrial park and that didn't make it.
As far as the comp plan, no, we won't be ready for May. 1 year was a real aggressive goal. More realistically, it's a 2-year project.
Okay, but I was just, like, they was looking at the industrial park for last year, and we're still not gonna see it this year, is what you're saying?
Yeah, but you're
They
talking,
won't-
comp plan and ordinance is two separate things, really. You're thinking of ordinances, comp plan is a lot more in depth.
A lot of the low-hanging fruit that we've talked about with the industrial park planning committee and the comprehensive planning committee, we're going to try to get to incorporate into the rewriting of zoning ordinance and try to get some of those things flushed out of year one. But it might be a multi-year process because I don't even think we know what all the issues are yet.
Yeah, is it all actually started from you guys up there?
Well, I think right now the primary direction that the Industrial Planning Committee is looking at is, do we have the ability to invite other landowners into that?
New property.
And go from 50 acres to 150 acres, and how do you develop that, and what opportunities are there for other businesses? That's the direction we're looking at right now.
And shoring up some of those zoning laws might be a first step to convince some of the abutting landowners that, okay, maybe there's something here. So it might take a multi-year step. It wasn't the original design, but things have happened.
We have no old business, so we'll move on to new business. Comprehensive planning consulting RFP.
In front of you, labeled draft is a 7-page RFP that the Comprehensive Planning Committee voted on to recommend to the Board of Selectmen. There's a little bit of structure to it, not completely foreign to the other RFPs that you've seen since I've been here. But the one things that I want to point out to the Board of Selectmen, if you go to the consultant response section on page 4, there is going to be a non-mandatory meeting in which people that are interested in bidding on this RFP can come and talk to the Comprehensive Planning Committee and kind of flush out what their thoughts are. There's also a mandatory letter that they have to have in that day, so we'll know who the consultants are prior to the actual opening of the bids. Proposals must be received by November 20th. That gives plenty of time for administration to put them together and tabulate how they compare, research references, bring it to the Comprehensive Planning Committee, have them interview, and then also get it back to the selectmen for a final approval. And then we're looking to contract sometime in December. That's a pretty aggressive timeline, but one that I think that is perfectly doable.
What do you think the cost will be?
Well, I think that most of these consultants are relatively hungry. And one of the things that the Comprehensive Planning Committee has done very well is they've worked on, this is where we want to focus, this is not where we want to focus. And I think once we show consultants their lists of priorities, based on the prioritization workshop that they did a month and a half ago, it's gonna tune these consultants in. They don't have to figure out what's important. They have to figure out how we write into a comp plan what's important.
In the original one that Jim had typed up for us, he had put in the amount that we had set aside for it, and the comp plan committee asked him to remove that. If the people that are making the proposals want to know, they can ask, but it doesn't need to be in there. Our feeling on that is, if you put in that dollar amount, most of them are going to be right around that dollar amount.
But what was the dollar amount we set aside?
30,000. And I think that usually the prices you get are based on how good your RFP is and how good your selection process is. I'm very confident this is a good RFP and a good selection process. And I think we'll get some good prices. One thing we saw with the sidewalk project is there's some hungry consultants out there right now.
Are you looking for a motion?
Not yet. You have a typo in it, Jim.
Oh, no.
Page
Wait.
4. Fourth paragraph down, second word, second line, next to original, it says 10, and then in parentheses 14. No, we want 14 copies.
Yes. And 14 is specifically for the 13 members of the Comprehensive Planning Committee and myself. So that's why we set 14. I don't know how 10 got in there. I think it's copy
So
and
I'll make
paste.
the motion to advertise for the RFP for comprehensive plan.
With corrections?
Yes.
Seconded.
Motion's been made and seconded to advertise the Comprehensive Planning Consulting RFP. Questions? All those in favor? Motion passes.
Congratulations. Big step from a year ago when we were talking about whether we wanted to put money aside to work on comprehensive planning.
And the comp plan committee is actually hoping he comes in much less than.
Still isn't me.
Next under new business, Boothbay Region Ambulance Service Budget Committee appointment.
We're doing
Who's
this
on
on,
that right now, Douglas or Dale?
Douglas was last year.
Yeah. That's right, you just get, that's right, brought back.
They asked for this, in full disclosure, asked for this like a month ago and it's gotten postponed. So the ambulance service wants to do their budget process like now since they're doing an interim budget for the hospital purposes.
You want me to frame up the day for the new ambulance for nothing, so maybe I should be on the budget. It's a sure
I've done
conflict
it
of
in the past.
interest.
I'll do it again.
Will you
But
budget in more
that's
money?
happy where he's at.
No, you can have it.
I have no comment. As you can tell, there might be a little conflict
You're
there.
gonna be putting
So if
the
you're
insulation,
abstaining,
right?
are you gonna abstain?
Yeah.
Okay, I'll make the motion that we appoint Dale Harmon to the Boothbay Region Ambulance Service Budget Committee.
Second.
Motion's been made and seconded. All those in favor? 3-0. Steve and Steve abstaining
Nothing to.
due to relationships with broads. Next, St. Andrews Task Force donation.
So the towns of Edgecombe, Southport Edgecombe and Southport have donated funds to the St. Andrews Task Force. And the town of Boothbay has leveraged other assets to this point. But Chuck asked me to place it on the agenda, and the town of Boothbay has the ability to leverage funds if they choose so. We would take it out of contingency or our legal funds. But I do think in transparency, what we would do is cut a check from ourselves to move it from fund to fund.
Yeah, the reason I've asked Jim to put this on so we could discuss it is I think it's pretty clear how the people feel about this. Every night the task force has a meeting, not only is this room filled, but that room is filled as well. We've seen the many emails. Jim and I have talked to quite a few people. I'm sure you guys have as well. So what I'd like to see is that we take $500 out of our contingency account to help the task force. And that would be my recommendation.
I guess I am fully supportive of that task force, and I want to make sure I say that right up front, because I think it's great. But, if they've got money, or you have money, I'll direct it at you since you're on that committee. But I mean, if you
I
have
am the
money.
chairman.
Right, I mean, if you have money, I mean, if you was needing it, I'd be all for it. If you don't need it at this time, and we've given us a lot to that committee, in Jim's respect. So, I mean, if you sit there and tell us you truly need a check, I'll go along with that, don't get me wrong, I'm not saying that a bit. But we've given a lot now, and if you don't need it, why? I guess would be my question.
Makes a good point.
We're gonna need it. Yeah.
I think it shows a good leadership position.
Well,
The McAvoy's Foundation proved that with their matching grant. They said, we'll leverage $5,000 matching, and then it flowed in. So I think the community is waiting for leaders.
I mean, I don't want to make it sound for 1 second that I'm against that. That's not my point at all. I mean, if I had my way and the town of Boothbay could afford it, we'd open up a hospital. You know, I mean, I know that isn't a reality, but you know what I'm saying. I fully support it, so if you feel that you need it, then I'm okay with that.
The attorney isn't cheap. And as Jim said, we have raised about $21,000. A lot of that was thanks to the generosity of the McAvoy Foundation by putting out that matching grant, and the people did step forward with it. And I'll be honest, guys, we're the ones that started all this.
Yep.
Oh, yeah.
And I think we should still continue to show our concern, and 500 really isn't a whole lot.
I guess in my own feelings is, I do agree with Steve. I mean, it's kind of, we're giving money. We've all heard a lot about this on the street, and I've heard a lot of, do not put any tax dollars towards this. I mean, that has been a direct quote from multiple people in town. At the same token, I am a firm believer in the task force. I'm a firm believer in the issues that they have, and they're trying to overcome.
Can I offer another possibility? What's in the account right now, Jim?
Last I checked, about 21,000, and I think that's missing about 3,000 of McAvoy's matching funds.
Okay.
Hold on.
Can I ask for?
Just
hold
one
on.
second.
Okay.
Just 1 second.
All right.
I'm a firm believer that I always live and die by every decision. Everything that comes off my lips, I'll stand behind. We did start this, and I am a firm believer in the task force. $500 is not a great deal of money. And I will be the first one to make a motion that we take $500, write a check to ourselves, to that task force, and that is an official motion.
Thank you.
Seconded.
I mean, we don't want to be the only town at this point.
It has nothing to do with that. I'm a firm believer in
Finish what we start.
Right, absolutely. We started it, we have to go the distance with it.
Okay. Motion's been made and seconded
Who
to
seconded that?
Steve. That the town of Boothbay donate $500 from the Selectmen's Contingency Fund to the St. Andrews Task Force. The only question I have for you guys is, how do you feel with me voting? I'm losing my voice again, sorry.
I don't think there's no conflict.
No.
Yeah, they're representing the town of Boothbay, not St. Andrews.
We appointed you.
Yes,
Okay.
I don't think there's any conflict,
All right.
personally.
Any other comments? All those in favor? Motion passes. Thank you, gentlemen. Public comment? Mike?
Is there a timeline of some sort with this task force with St. Andrews? How, are they trying to accomplish specific goals or objectives within a 2 or 3 month period?
I would say that the drop dead date is April 1.
Okay.
Lincoln County is very strong in their stance that they won't budge off from that unless something new comes up that they don't know about. We had asked them for more time, and asked them to extend it to October 1st to give the task force and the community the chance to really look at this. And their response was basically no. That they had already done all their studies, they had already looked at everything, and it needed to be done April 1st. Like I said, unless something unforeseen pops up and that they hadn't looked at yet. We have a number of different groups looking at things. Bruce McDonald's group is a subcommittee, and they're looking at the community hospital aspect. There's another subcommittee that's looking at their financial analysis. Mike Pander and Mr. Twaddle
Yes.
are heading up that group. We're looking at the ambulance service and what they may need. Valerie's been heading up the fundraising.
Unofficially, I think, yes. I don't think she wants the
Stuart
leadership.
Smith has been looking at economics as well as what MDOT may need to do to upgrade River Road to make it fully accessible for the ambulances year-round. From what I understand, our friends in Newcastle and Damascotta are themselves having a few reservations about all that new ambulance traffic that may be going to Miles and how it's going to affect them. To be honest, I haven't asked Lincoln County if they had thought of that, but it sounds like nobody had talked to Newcastle or Damascotta about it, kind of like they hadn't talked to nobody down here on the peninsula.
Oh, but wait a minute. We got a letter here asking for our participation now.
That letter is very interesting, Steve, if you look at it for one reason only, and that is that the community committee that St. Andrews is looking to put together, and thank you, Mr. Donovan, for sending us this letter. They're looking to meet for at least the next 18 months. April 1 is only 6 months away. I'm not quite sure why the extra year was added in there for the community committee to meet. That would be a question for Mr. Donovan.
In order to establish a hospital, there's a pretty important designation that you need to get through DHHS in order to establish a hospital. So you don't need to have that designation to alter the services at a hospital or to continue maintaining a hospital. So once the hospital goes away, I think it would be hard for the region to get that designation back. And then also you would lose the, what's the other?
Critical access.
Critical access designation at the same time. Both of those things are going to be hard to get back. So essentially if the hospital itself is no longer there as a hospital as of April 1st, it would be a huge uphill battle to get it back.
You'd have to provide a certificate of need for the community.
That's it.
And you can bet your bottom dollar that Lincoln County Healthcare would fight that certificate of need with all their documentation of reasons why they close the hospital.
Did I answer your question, Mike? Or
Yes, yes.
Yeah, so I think we're trying to beat April 1st.
Yes.
One final comment regarding a discussion we had earlier tonight regarding the Stimson violations. I really hope, and I don't know if any of us can predict where this is going to end or what's going to happen. One of the things I really hope is there is a lot of thought put behind an ordinance change because of one person, if it goes in that direction. That will set a precedent in this town, and it would allow others to plead their case and say, I'd like to see changes in the ordinance because I feel I'm aggrieved, I haven't been treated fairly. And I don't know where it's going to end, how it's going to end, but I just hope as a whole town, everybody considers that, because this can have long-term effects on the ordinances in this town, the zones in this town, and affect a lot of people. So, anyway.
I agree with you, Mike, and that's why I said it's not just a quick fix. It's going to take time to look at it. It's going to take a long time.
Yes.
Somebody would have to come up with a proposal, take it to the CEO and the planning board and have them buy into it after they have their public meetings and their workshops to take a look at it. And then they'd have to bring it to us to take a look at, to even recommend a town meeting. And that takes quite a bit of time.
You know, I can look at if boat building somehow is allowed, that's a manufacturing use. To me, that implies that now River Road, manufacturing is an allowed use. I could relocate my business to River Road. And that's the danger, that's the real complication that has to be looked at in this whole process.
Or you make an ordinance so nitpicky or so hard to define because somebody wants to say it's just gonna be boat building and no other kind of manufacturing, which makes the ordinance impossible to read. Or a lawyer gets involved in it and he interprets it someplace totally different than the way I would interpret it, the way you would interpret it, the way Jim would interpret it. So again, it's one of those things where I know we have this room full of people and I know emotions run really, really high for this. But it's more than us just saying we've already made our minds up and we're done, because that's not it at all. There is a process and there's a process for a reason.
Yeah.
And I'm kind of glad that you're sitting here instead of Dan, because he wouldn't like this. But, you know, everybody loses when the lawyers get involved. You need to be able to look at things with common sense and what's best for everybody, not just one person. I feel for Mr. Stimson, I do. But the townspeople voted in that ordinance, and the town has to uphold it. And if he decides to move forward with an ordinance change, I'd be interested to see what that would be, because it's like you said, if it goes in just on manufacturing use, you're opening up everything. And that can change the character of not only that section of town, but the whole town.
Anything that's general residential.
Yeah.
Chuck, one of the things that we have to worry a lot about, nobody uses it, is we only have to have like 10% of the last people that voted to change something like that, if it's petitioned.
10% of the last
Vote.
gubernatorial vote.
And if you got enough people upset over a small issue like Mr. Stimson's, 10% isn't that big of a deal.
That's state law, that's nothing to do with
I
us.
know, but that's not a big deal to change something.
Nope.
And we could be in a big mess just because something's small.
Even with that, Martin, and 10% isn't a whole lot, considering how few people come out and actually vote.
Yeah.
But you still have to go through the entire process before we could even set a date on when to have a special town meeting. And the process can be a long one. I'm not trying to sound negative on that. But in order to make sure that the best possible proposal goes before the voters, it's going to take time. It's not going to take a couple of weeks or a month. You could be looking at 6 months or more.
And then
Between your public hearings and all of those have to be noticed. If there's any workshops involved, those need to be noticed. And that's just for the planning board. That's before it even gets to us.
when you change it, it could be something we couldn't work with at all for a long period of time.
And just so people understand that a special town meeting is actually not an avenue in this case, because our zoning ordinance specifies that the zoning ordinance can only be amended once per year, and it was amended at town meeting last year, so the next time it can be amended is town meeting this year.
But our town meetings only show up with 70, 80 people.
I agree.
Okay? You see there was 30 people here tonight, okay? Those 30 people bring one more person, you've got more than you'll ever have at a town meeting.
There are options for that.
Right, you could put it out to written, you could do it a written ballot.
You know?
Yeah.
Not if they petitioned it that way, that it not be a written ballot.
No,
that it be changed.
the selectmen get that authority.
They can petition for a special town meeting if they wanted to, but it's up to the board of selectmen to decide whether it's going to be a hand vote or a ballot vote.
Yeah. You better honor the wishes of the voters.
We would be.
I mean, if they decided that that's the way they wanted it to go forward as a hand vote, and you guys decided it was gonna be secret ballot, you know what I mean?
You get the same results either way.
So, yeah, but you're more apt to get people to come out and vote for a ballot vote than you are a hand vote. If you have a hand vote, either side could pack the room.
That's what I mean.
And if it's a ballot vote, you get.
Special interest groups.
If I was planning on packing a place, that's the way I do it.
Now, rather than, so, excuse me, but, rather than live in fear of this, of what we've worked so hard to put together as a set of rules for the town, is there a way to, say, coax these people who are in this gray area out? I mean, there's a lot of people who work in residential businesses, who are just, one, don't even know they're in violation, two, don't care, and three, I mean, there's tons and tons of reasons why they're doing it. I mean, like I said, I started mine out of my van.
A lot of times people don't know what's in the ordinance, Alex. And 9 times out of 10, they don't find out that they're in violation.
Hey, if you're, I mean, obviously this wouldn't work, but like, hey, if you're in business, come in and get it on paper, but I mean, I know people are too scared to even do that.
Yeah, but the thing is, right now, you might be grandfathered now. 10 years from now, the townspeople may decide they want something completely different. If you're in compliance today and you don't change after that ordinance is changed, you're still grandfathered. You can't expand as a non-conforming use, but you can still continue what you're doing today if you're doing it after that ordinance changes. However, as a grandfathered use, if you ceased that use for a full calendar year, 12 months, you're no longer considered grandfathered.
Oh,
Because
yes, I get
that use ceased, and then you'd have to fall under the current ordinance. But if you don't cease that use, you're still grandfathered.
Yeah, I would say just not only that, I agree with all of that, of course. I would say not just getting these people out of gray area, maybe the town should say, I mean, the town's got a really great handbook on shoreline zoning. Maybe it's a state handbook the town adopted, I'm not sure exactly what its whereabouts, but it's great. It's very informative, it has the code in there, it also speaks at a personal level, and I believe the town, or the code enforcement branch of the town, put it in the paper, said, hey, come ask us about what you can do. It's amazing what you can do. And it is. A lot of people think you can't do anything. You can do a lot of stuff. You just gotta follow the law to the letter. And maybe the town should just adopt a happy little thing like, you wanna start a business? Come see us. Maybe just add the paper, come, an article. Come see us, come see what you're allowed to do. Are you really interested in starting a business? You should be interested in how you can do it. And I'm at fault for not doing this correctly myself. My business covers 10 states now. I have to deal with zoning and ordinance in New York City, Boston. I think we've got it really good here. I hate to see a petition started to tear it down, or cog in the works. I love the fact that we're working with this guy to work it out. I think it's great.
Well, in your case, I probably would have thought some of the things that you're doing. I mean, your dad had his business up there for years.
And that's what I thought. I'm the vice president. The business still exists. We can't dissolve it. And when I came, I had to sit in front of the planning board because even though I interpreted it as, I'm in my same wood shop, I'm building stuff out of wood, this is what we did. Okay, well, I'm just doing the same thing. I was like, oh no, you changed the name of your business. Well, yeah, I can't be Rio & Sons Marine Construction anymore. We sold off our assets. I can't do that. The president says I can't. So, well then, if you change the name of your business, you're at fault here. And I was at fault, and I had to come in, and I was terrified. But when I sat in front of the planning board, and it was all done, and I walked out, and I went, wow, that was great. I'm a valid business. I have it right here. I can abide by these rules, and I can do this, and nobody can take that away from me. This is powerful. And I wish I had known to have done that right from the start. But I mean, honestly, even if I had sat down and read that code from beginning to end, I don't think I still would have thought the same way. I still thought, I'm fine. It just happened to be one of those things like, you changed the name of what you're doing, you changed the sign was down. Then they looked in the file, and there was no Louis Rio Marine Construction, there was no Rio & Sons Marine Construction. To tell you the truth, I think when my dad started Rio & Sons Marine Construction, he actually needed to come before the planning board, but he didn't. So, and he's been at every single one of these meetings I've ever seen. It's confusing for people who are in it to still be in it. I'm in it. I'm on a committee. It's still confusing. At some point, I'd like to see that be less confusing. But I think that just a show of support from the town. Like we support business. Come here and we'll show you what you can do and what you're allowed to do and how to do it. And if you're allowed to do it, and if not, there's avenues of places you like Mike said earlier. Hey, David, come up to the industrial park. or go to a C2 district and, maybe there's somebody there that'll let you do what you can do, or C1, or, sit in front of the planning board, or go to the industrial park, not have to do that. What if he was building a tanker up there? They're right, there's no definition of what a boat building is. You could build you could wash them dirty, you could build a 600-foot tanker if they wanted to. And I don't want to just, I didn't like it when somebody came into my business and said, hey, stop working or anything, this is terrifying. But at the same point, I totally agree that I wouldn't want somebody building a tanker next door. As absurd as that sounds, what is the limit? Where's the line drawn? Is it always doing a 10-foot dory in his barn, or is he doing a 50-foot steel boat in his yard? Would we be having the same conversation if it was a slaughterhouse? I think just the town should say to the people, hey, you think you might know what's up, just come talk to us.
Yeah.
And
I think I can speak for the code office here and say they don't like having to come to somebody and say, hey, we got a problem.
I know they don't.
And I'm the first one to be a critic of our zoning ordinance. I think I have been for the past 2 years. But I'd also say that our current staff in code enforcement is the most conscientious code enforcement staff that I've ever worked with. And they're going to be advocates for people that come in before there'll be enforcement. Speak to Lori, speak to Dan, speak to Art, speak to me. If you don't want them to come out to your property because you think they're going to notice violations, come speak to me. I'm not gonna throw anybody out. One of my first things in statute that I remind people about all the time, in state statute, under the town manager's responsibilities, is to help people navigate this government structure that we have. And I'm going to tell you, well, it's in your best interest to get a code enforcement officer there, or it's not. And that's where that conversation ends. But speak to Lori, speak to Dan, speak to Art. They're very conscientious people. They're going to get you pointed in the right direction. Understand that the ordinance is complicated. We're working on trying to get some proposed changes to simplify that. And we appreciate the support that comes from some people. And Mr. Stimson had even said at one point in time when we were discussing, he's like, personal feelings aside, and I said, let me assure you, there aren't any personal feelings. That we're just trying to handle business. I'm actually very empathetic. I understand the situation he's in. I hope it all works out for him.
And I've gotten that from the town. I've gotten that from many boards, and I think it's great. And if I can be swayed to think that what we're doing is progressive, then that the rest of the town maybe doesn't feel that yet. And I'm asking, what could the town do to better their ability to do that, to help people, to say, hey, I'll help you navigate this. Like I said, one of my suggestions, article in the paper. Not a lot of people read them all, but
I think Jim's just said it though. He said the door is open.
Door's open.
The door's open.
But Mr. Rio has some good points. The shoreline zoning flyer that we put together was my frustration at our code enforcement officers. Said, you answer the same question every single time somebody asks you about shoreline zoning and tree cutting. Put it in a flyer. Save yourself a few minutes. When somebody comes in to ask a question, here you go. We put it on the website. Now, if we had the time to do a few more of those flyers, okay, now my question is not shoreline zoning and tree cutting. My question is, what are the allowable uses in my residential zone? Here's your flyer. If you don't understand it, we'll sit down and talk to you about it too.
I'll help write one.
Yeah, and I think we need to get there, one step at a time.
I don't want to jump too many steps, but I'll help write one.
No, and we appreciate the help.
I gotta say, every time I've ever come in here, I've always been treated fairly.
You have?
Yep.
Well,
I don't know why.
We'll change that.
Even mine, wow.
I have. I've had a couple of issues, and I've either gone to the town manager or to the code enforcement themselves. If it was something that the code enforcement I didn't agree on, I go to the town manager and it got taken care of. Even the past town managers in code enforcement, they've always worked well. You can't read that and understand half of it. You'd have to be a lawyer yourself on a lot of it. And I think most people don't want to be in violation, they just don't know.
Yeah.
If somebody points something out to most people, they're gonna correct their violations. They don't want to be fined and they don't want it to be wrong. It's just, you can't read it. Your interpretation of something is one thing, mine's another.
Then the biggest problem with that is the fact that the lawyers have gotten involved over the years, and we've gotten away from common sense because they need their legalese to make sure that only they understand it.
Well, they're professionals in finding gray areas.
They
They
get
can
paid for
create
it.
one.
They get paid $300 an hour to find that.
And the more typeset you have in the zoning ordinance, the more gray area you're gonna
Oh,
have.
yeah. The longer, more drawn out it is, the more things there is to find fault with.
Anyone else? Brian, missed you.
Yes,
I've been soaking it all in. You talk about Southport and Edgecombe and now Boothbay has donated towards the task force. You left Boothbay Harbor out.
Boothbay Harbor has not donated.
They have not done anything. Okay, and so you guys have put forth 500. What about Southport and Edgecombe?
500 each.
500 each. Okay.
Has Boothbay Harbor been asked?
Well, we asked.
Yeah, they talked about it at the last selectman meeting.
And they didn't approve
There's
it?
a possibility they may talk about it tomorrow.
They're talking about starting to think about it. I guess. I'm sure it'll come up. So.
Yeah, you'll be there.
I don't know if anybody's supposed to be straight faced when you say that.
Well,
I tried. I really did.
I can tell you, Frank, that I did speak with one of their selectmen and asked him.
Did he gavel you?
Did
he gavel you out?
No,
Okay.
no, it wasn't him, and it wasn't Valerie. So.
Okay. I'll try to sneak it in if they don't talk about it.
But, you know, the thing that kind of upsets me about the Stimson thing is, I mean, they just say we're not sympathetic, we're not this and that. We have rules to go by, and when I am out in public and people say to me, what kind of a power trip are you guys on? That is really dumb.
They don't, the same people don't understand the ordinance.
No,
I
they
think you guys
don't.
are, that's why I didn't want to villainize you when I spoke. I said, I support these boards, I support these rules, and I think that most people, if they could have the same experience that I did, they would, they would change. They would say, oh, well, geez, what I'm doing is illegal. And maybe they just don't make light of it. Or two, try to conform. And I don't think most people are going to run to a lawyer and try to say, oh, I have the right to do all this stuff when they see that they don't, and that they take the accountability and the responsibility for the fact that they voted it in.
I hope officially.
Well, nobody likes to be told they can't do something.
No.
That's worst
Starting
case.
a business
That's worst
or
case scenario. If it comes back
drive
to
a
us.
certain way or any of that. It's just human nature. We have to try to. Everybody has to try to be more problem solvers. And try to get out of the whole.
If you want to understand it, you have to get more involved.
Right.
If you don't understand it, then.
That's why I'm not home watching The Voice right now.
Oh,
I think.
It wasn't for DVR.
You need to. You're taking it on.
Oh, yeah. Tape. That's what we use now, Steve. Is tape.
I think a lot of times what it's happened to is we want to see our neighbor have a business, we want to see everybody have a job and stuff, but it's an awful thing to say that a lot of us in the back of our mind has got what a few people years ago say like the Walmart syndrome, and we're afraid to watch our neighbor's business grow, and all of a sudden he does have 50 employees, and he is building 100-foot boat. But if it was the guy, 3 guys, father and a couple sons building a wooden boat, and they got 50 feet, you probably wouldn't say much. But where does that stop? Once you let that animal out, it's pretty hard to turn around and bring him back in, Well, we want everybody to have a job, and a place to do it from.
Well, there comes a point where you outgrow where you're at. And you need a bigger area to be able to expand your business. And sometimes a bigger business just doesn't fit into a neighborhood. And that's the fine line you have to look at when you're looking at all this. Using the scenario that you were talking about, Martin and the father, and 2 sons working on a boat, that might be all set for a small neighborhood. But if you're starting to talk about 50, 60, 70-foot boats, when does that stop being something that the father and son is working on together and being a shipyard? And that's the line you have to look at.
And another thing is, if that was a personal boat, and he was gonna be a fisherman with it at the end, I think we'd all be cheering him on, building his own boat 50 feet, gonna go work.
Well, I
No,
believe
if
under
he was
the,
banging on steel in Mike's backyard, we'd still be doing this.
I believe under the current ordinance, Jim, help me out on this one. If you're building your own boat, you can do it.
Yes.
Right,
It's an
But
allowed
if you're
use.
building a boat for profit, you have to fall under the ordinance.
right.
Vote for himself, we'll sell it.
You should
That's for
definitely do
profit.
There you go. No, well, 50.
that.
Well,
They got a business, and that other one's not a business.
How many are you up to?
I'm not at liberty to say so.
I have to apologize, Frank, of the assumption that you still had the VCR. I didn't mean any offense.
Well, quiet, we're being,
VCR. I
this is
didn't mean
being
any
taped,
offense
Mr.
by it.
Ham. It's getting taped right now.
All right.
Can,
Any
can
other comments?
Can I get one more comment?
No.
The system works. I'm a big local government fan. I didn't get into local government because I didn't think the system works. If everybody does their job, the system works. But that means that voters have to show up and they have to vote for the appropriate questions. And if the ordinance doesn't fit what the people think it should fit, the right people are there to fix it. The system does work. I know that the first thing people want to do is villainize City Hall, and I understand that mentality, and that will probably get a lot of traction in this particular case. But everybody in this organization, the town of Boothbay, is attempting to do their job at the best of their ability, and the system does work.
Thank you all for coming. We'll review the warrants and sign them, and I'll entertain a motion to adjourn.
Motion to sign warrants.
I'll make a motion to sign warrants upon review.
Okay. Motion's been made and seconded to sign the warrants upon review. All those in favor? And I'll entertain a motion to adjourn.
Second.
Motion's been made and seconded to adjourn. All those in favor? Thank you.